Welcome everyone to Generative Artificial Intelligence and Copyright Concerns, Legal Marketing and Beyond. I'm Andre, your program host, and before we begin, here are just a few housekeeping items. To send a question to the presenter, type in the box below the Participation tab. Program materials can be downloaded from your Supplements tab. We also encourage everyone to take a few moments after the presentation to give your feedback. A link to the survey can be found underneath your viewer window. It's now my great pleasure to introduce our presenter panel for today, Melissa Rogozinski, Joy Holley, and Stephanie Wilkins. I'll turn the floor over to them now for further introductions.
Thank you, Andre. Really appreciate everybody being here, and I'm really excited to have a conversation about GenAI and copyright concerns and how it impacts marketing and our legal practice in general. So I'm very excited to present with my colleagues and friends, Joy Holley and Stephanie Wilkins. So just a 60-second introduction from each one of us. My name is Melissa Rogozinski. Everyone calls me Rogo. I am the founder and CEO of RPC Strategies. I have been in law for 28 years. I was a paralegal for 11 years, and then I went into sales with court reporting, video, trial, and e-discovery company. And I have been an entrepreneur for the last 11 years. My first company was the ESI Roundtable. I did about 300 programs on e-discovery, data privacy, cybersecurity, all CLEs. And now I have RPC Strategies. We are a marketing and sales consulting firm, and we focus exclusively on B2B SaaS companies, legal tech companies, and boutique law firms. Joy?
Thanks, Melissa. Good morning, everyone. I'm Joy Holley. I'm a lawyer, a legal operations consultant, and AI enthusiast coming to you from St. Louis, Missouri. I also have a background in electronic discovery.
Stephanie?
Good morning, everyone. I'm Stephanie Wilkins. I'm the editor-in-chief of Legal Tech News at ALM. I am a former lawyer, still licensed, but not practicing, but have been writing in the legal technology space for about a decade, and I've been with ALM for just over a year now, and also an AI enthusiast, I would say.
So in today's program, we're going to talk about marketing, but we're going to provide you with a very strong framework and guidelines so that you can really harness generative AI and LLMs to enhance your skill set and strengthen your business. And so I kind of want to set the stage with why this program is happening. Let me go back one slide. So I'm going to share a story here, and I know that we've got live attendees. This is going to be on demand. This is the first time that I have shared this story publicly. When OpenAI launched about a year ago, and there was just a flurry of activity around learning how to use it and setting up accounts, and along with that, very quickly came a lot of fear and a lot of concerns that generative AI and these LLMs were going to put a lot of professionals out of business. And creators and content marketers were absolutely at the top of the list. Lawyers weren't far behind, especially when these programs passed bar exams. So the truth is, I was very resistant, and I watched it for a while, until I lost a client to AI. So can you lose business to these programs? Yes, you can. So it forced me to do the research because it threatened my way of life. It threatened my business. And so I did the research. I talked to a lot of people, which is a lot of what you're going to see in the content in today's program. But what I'm here to tell you is 6 months into this, now I'm able to use it. I have developed a very strong skill set. I've been creating a lot of content about AI. It's all original content. And I've learned how to leverage it not only for my business, but now I'm also learning how to help clients use it to strengthen their businesses. So we're going to go through some of that and on how to use this properly and what the laws and regulations say. So I will say this, that by the end of the program, for you to know that I've strengthened my pipeline. And if you learn how to use it the right way, you'll strengthen your business. So we're going to talk about practical business and legal impacts of generative AI in marketing. We'll talk about ethical rules and the pending regulations for generative AI, copyright law, who really owns what's created, how it's created, and issues of some of the outputs of AI. And then we're going to tie this up with how to adapt to it, strategies, and training for your practice. So I'm going to start a little bit with patience. Like I said, I kind of set the stage with the story of how I lost a client to it, and I was forced to deal with this in order to figure out if I was going to save my career. And so being a paralegal and being trained by lawyers and working with lawyers, I know how to build a case. I know how to do the research, and I have to take my time. And so that's why I start this off by saying patience is a virtue, because in a situation like this, as with any of our litigation cases, transactional work, anything that we're doing, we're faced with a challenge, and the outcomes, how we handle that, how we get to the outcome is really important. So it's really important to remain calm and focused during these challenging circumstances. The fact of the matter is that AI is not new to law or legal tech. We're accustomed to this for at least the last 15 years in e-discovery. Think about predictive coding or technology assisted review, or, we always, in sales, we used to tell the story of when you go to Pandora and you type in the name of an artist or a song and it generates an entire radio station or playlist for you. That's artificial intelligence. So it's not new. It just has a shiny new package called an LLM. An LLM is a language learning model. Did I say that right, Stephanie? Language learning model.
Large language model.
Large language model. ChatGPT, Bard, and Claude are all branded LLMs. Anthropic, the company that built Claude, defines it as a helpful, honest, and harmless assistant with a conversational tone. And that's how you should think of as an LLM or any other technology that incorporates generative AI. It is an assistant only. You cannot take it at 100% face value, and you need to take the time to learn it, experiment with it, and stay informed about the developments, because every single day we're having multiple articles come out about how AI is evolving and how to use it.
Can I just add on the patience front? I think, myself included, people need to step back and realize just how new this generative AI wave is. It's only been a year since ChatGPT came out. It feels like a lifetime because it has moved so much faster than everything else. So a lot of people are like, oh, why is it not doing all the magic yet? But we're moving exponentially faster than any other technology has. And so it's just important to remember that we are still in the very early stages of it, even though it has already created so much change.
Go ahead, Joy.
Yeah, no, I just wanted to add that if you have not had an opportunity to check out one of these free and readily accessible tools like ChatGPT, check it out. And I recommend prompting it about a topic that you know a lot about. So that doing that will help you understand the nuances of it or lack of nuance to it, and will help you understand and get your arms around what its parameters and limitations are.
The topic you know a lot about that does not involve client information.
Yes, thank you for that. Thank you for that. Yes, generic topics.
Like if you're a master at making cakes, talk to it about making cakes. Like, yes.
I used it on my last birthday we had a bunch of ingredients for a cocktail and we didn't know what to call it. So we put all the ingredients in and it gave us a list of 10 names. So, test it out on easy things like that. Be very careful about client information. So, but yeah, so testing it out is really an art. And like I said, it's an essential step. And again, be patient. Don't let the hype and the fear and this whole apocalyptic doom and gloom, worry you, because, it's just not that. It is a very impressive tool, and you can learn how to use it to your business benefit. So, but take the time to test it and learn how to incorporate it in your legal marketing and your business practices effectively. we're all legal professionals. Use your judgment. This is what we do for a living. And you can really harness the power of AI to enhance your marketing, your business. So some of the things that I did to test it out was I started learning I put in some email. I wanted it to write an email to send out a social media calendar for the year. Or I wanted to see how it would do writing a social media post for me. I mean, I'm pretty effective on my own social media, but I wanted to see what it would do for me. And that's where I learned how to start prompt engineering by giving it more details, more information. I upgraded to a paid version where I could give it some directives that for how I want an email, how do I want a blog article, how do I want a social media post, how many words, like what voice do I want to use. There's a lot of things you can put in with that. And the next thing I did is I talked to other colleagues, other legal marketing colleagues, and I talked to probably 3 or 4 of them, and I asked them, how are you using this? And so each one of them took time. They gave me their insights, they gave me additional tools, they gave me guidelines that they used, and conduct multiple tests until you are comfortable that it's putting something out that you feel like you want to use. But again, and I'm going to hammer this home during my part of this presentation, never, 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 ever take it at 100% face value, okay? There have been many times that I've gone through all of these exercises and I've iterated through prompt engineering 4 or 5 times and still not been happy with what it gave back to me, and just simply didn't use it at all. I just will write something from scratch on my own. So be patient and test.
Yeah. And I would say that even like some of the companies making the most powerful tools out there have been doing it through trial and error. I mean, they'll even say like these models are inscrutable. Like they continue to surprise the most advanced coders and developers out there. So everyone's in very much a trial and error phase with this. It's all testing, and it needs to be, and it will be for the foreseeable future.
Yeah. So through patience and through testing, I did go from being very resistant and upset about it and losing a client to being very impressed with results and using it on a daily basis now. So it's, how can you leverage AI in marketing? It's fantastic to help you brainstorm for ideas, or, if you want to write a 1-page marketing flyer for your practice area, and you've never written a marketing flyer before, you're used to writing briefs, you can ask it what does it need to help you write a marketing flyer, and just iterate through prompt engineering until you get something that looks like it makes sense to you, So, optimizing it, I mentioned this earlier, upgrade to a paid version so that you can put information in about your profile and your voice and who you are, and directives so that it can start putting out the kind of content you want. Like with social media, I will usually ask it to write for a company page post 150 words and to summarize this blog article, help me promote this, give me some calls to action, things like that. And I'll give you some more ideas for marketing and sales here in just a minute. Joy, Stephanie, did either one of you want to add to that? Okay.
And I think we'll get to it in the coming slides. Yeah. Sure.
And just make sure too, one of the most important things that one of my colleagues told me is after I give it all these instructions to make sure that I tell it to remove redundancies, because the first time that I used it to write an article, I gave it 5 questions to answer for one article, and every response it gave me was worded just a little bit differently, but the message was really redundant. So that was the first time I learned that lesson. So whatever directives you give it, make sure you also tell it to not be redundant, to remove redundancy so it's not repeating itself.
And I will say there is, for better or for worse, largely for worse, the internet has been flooded with AI generated content in the past year. A lot of it not great, because sure, it can spit out things really quickly, and there's, my inbox is flooded with PR that you can tell was written by AI. It's not good. So if you are in this and this is your space and you want to keep your voice on it, that's why it's, as Melissa said, it's extra crucial to tailor it and reread it and use it as a starting base, because you don't want to get lost in this flood of just AI spewed content out there.
If you really want to solidify yourself as a thought leader, your content has to be native. It has to be creative, and it has to be you and your voice. We're going to get into some copyright issues later. And actually next month, we're addressing that topic on how Google responds to AI created content. Spoiler alert, it's absolutely not doing you any favors. So we'll get, Stephanie's laughing. She already knows the answer to that. We'll get to that next month. Okay, next. All right, so just a list of practical ways to use AI in marketing. Blog articles and alternative SEO friendly titles. Again, I am begging you, please don't ask it to write the article for you. You need to have very specific directives. You need to have very specific points. You need to have your hand in this. Okay. But one of the things you can do when you write your own content is a great thing is to ask it to give you 10 alternative SEO friendly titles. Because in legal, we write for a living, but we're not necessarily SEO specialists. But these LLMs are great for helping you with SEO friendly titles so that when you do put it out there, Google will find it. I've also used it for summarizing. I write my own Q&A scripts when I do videos and podcast interviews, but I do take that script and I'll put it into an LLM and ask it to summarize podcast show notes or a YouTube video description so that I can put that up. And again, back to the social media, I can use it to write a social media post for me. But I always use my own content to feed the LLM. I never ask the LLM to create something brand new for me. Okay, and we're going to talk about that why here in just a little bit. And then other ways to use it in sales. This is great. So I use a tool to record all of our meetings. So I have the audio and I have a rough transcript, but I can use AI to summarize those meetings and to identify action items and who's accountable for that. I also have used it to do a little bit of research on the competitor landscape for a client. And then also, I don't really like cold outreach emails. I've never liked cold outreach in sales, but I had to come up with a couple for even myself. So I used it, again, based on my voice and some things that I really wanted to promote. And I asked an LLM to give me about 5 different suggestions on a short, cold sales outreach email with a call to action. And I did feed in all of our information from the article and the slides to help me summarize some of these PowerPoint slides for today's program.
I would also just say, even just more generally, it's a great brainstorming tool. Like if I just get stuck with writer's block or looking for a good headline, not even for SEO purposes, I might say, give me 10 headlines for an article about X. And I might not use any of them, but one of them will have that one word that I just couldn't think of that will spark me in a whole different direction. So it really is a great little assistant in that way too, even just at the very basic level.
That is exactly, I'm glad you brought that up because that's exactly what I did when Joy and I did a podcast and a video interview a couple months ago based on a couple articles that she wrote. And I went in and I asked it to give me 10 titles for this. And I didn't take any of those 10 titles at face value, but I did see pieces of a couple that I was able to put together. And I knew that it would make an impact. And Joy and I talked about it and we're kind of like, is that going to offend somebody or is it just going to get a whole lot of attention? And we went ahead and took the risk, and it did. It got a ton of attention for us. And it was fantastic. I could not, even though this is my job, I could not have come up with a better title on my own. It was a fantastic tool to use for that purpose.
Well, and I think that's part of it too, for anybody who spends a good portion of their day writing. Eventually you just run out of ideas, or there's times you're worn out, or there's just writer's block. And I mean, we're great with words, but it also means there are certain times that I'm like, why can't I think of that word for that thing? It's frustrating.
You're right. It's a technology tool and it doesn't get tired. It doesn't get fatigued like we do.
Absolutely.
Right.
Absolutely. Those are all great points. So I want to just take a few moments to set the stage for us in terms of the rules and regulations that apply to this rapidly evolving landscape. So the takeaway in this section is that The regulations are evolving as fast as the technology itself, but in some cases not fast enough to keep up with it. And there are many sources that you need to consult in terms of the responsibilities of lawyers, of law firms when dealing with this disruptive type of technology. So first we have the ABA rules. So these are kind of the first go-to place for lawyers, either the ABA model rules of professional responsibility or, the state equivalents. And in some states, they're slightly different. So, just kind of from the start, Rule 1.1 on competency, the comment 8, which has been in the rules for a while now and received a lot of attention and discussion when advanced analytics for e-discovery first came out, is this responsibility to stay abreast of the benefits and risk associated with relevant technology. Never has that been more true than today with generative AI and the types of impacts it has, not only on our legal profession, but on the professions and the industries that all of our clients work in. So, there's really a broad list of reasons to stay abreast of these issues. The ABA, the American Bar Association, also releases resolutions. So they are sort of position statements on what their view is on artificial intelligence and how they will be considering regulation, position statements, lobbying, things like that with respect to a particular topic. There are a few of them that you could look to in this area, but I wanted to highlight for you ABA Resolution 112, which interestingly came out before ChatGPT. As Stephanie said, it's really only been a year, even though it seems like a lifetime. But Resolution 112 gives us some good ideas of what the concerns are kind of broadly across the base of the judiciary and the legal profession, and beyond in society. We're all very concerned about the potential for bias, the need to be able to explain this technology to a court or to a client. Transparency, being transparent and not having this idea of a black box, which causes distrust, and ethical and beneficial usage of AI. We've heard a lot about that, especially in the past several weeks in the context of OpenAI, what happened with Sam Altman and that whole debacle with, the board kicking him out, and then he was back and, he went to Microsoft and all of that. And then also controls and oversight of AI and the vendors. Practically speaking, most of us are going to be looking to third parties, partners, vendor partners to provide this technology. It's not really a lawyer's core business or a law firm's core business to develop this technology. A few are, but mostly we're going to be partnering with vendors. And it's very important that we have oversight, the proper type of due diligence and controls over them, so that we understand what we're buying, what we're using from third parties.
And I would add just to what Joy said there is that I think that's key. Like, it's not going to be most lawyers that are building these things, but don't think that it absolves you of the duty to understand it.
Right. Exactly. In fact, that is fleshed out here in some of the other relevant rules. So rules 5.1 and 5.3, this duty to supervise. Keep in mind the relatively recent switch of that language, assistance, plural, to assistance. So it applies to AI as well as, assistants, paraprofessionals, the traditional type of professionals that lawyers would oversee. It applies to technology. Rule 1.4, duty to communicate. Do you have to obtain an approval from your client to use this technology? Do you have to tell them if you're not using it? What kind of disclosures do you have to make in a litigation or dispute context to the court, to opposing party, to regulators, to the extent that you're relying on generative AI in part to formulate, the documentation of what you're providing in that context. And then confidentiality, goes back to the great warning that Stephanie gave. Don't be feeding in, proprietary code. Don't be feeding in information about clients or about your practice to the extent that you're using this for marketing. You want to be careful what you're disclosing in your prompts in terms of, what's competitive, highly sensitive competitive information that you don't want out there. You have to just be careful about what you tell it, so to speak. And then, again, the safeguards to protecting it, all the safeguards that we think about to maintain and preserve our attorney-client privilege. A lot of these issues come up in this context of generative AI. And then on the right hand, just a few of the many issues that this technology raises. Of course, data privacy and security, that goes without saying. In this context of marketing, intellectual property rights are particularly important. And Stephanie's going to get into that a little bit more. The potential for defamation. We've seen cases reported in the news and in the legal journals about, people who relied on information they got through ChatGPT or other tools like that about background or in the context of hiring. It turns out that it's wrong, and that can set you up or set a client up for a defamation case. And then again, this persistent potential for bias and discrimination. Okay. After, I think many of us are probably familiar with the Avianca case, Mata versus Avianca. It's a Southern District of New York case where the so-called ChatGPT lawyer who didn't really understand what ChatGPT was, thought it was more like a traditional legal research tool like Lexis or like Westlaw, relied on it and the case citations it provided to file a pleading in federal court. And then lo and behold, the ChatGPT had made the cases up, what they call hallucination. So the court and opposing counsel, very quickly caught on to this when they tried to look for the precedent that the lawyer had cited. Long and short, and it's all documented in the news, he ended up being sanctioned pursuant to Rule 11, and I think it was a $5,000 fine. But the embarrassment and public humiliation was much worse than that in terms of his professional reputation. So I think that's a pretty clear case for Rule 11 sanctions. So keep that in mind. That there is a lot of discussion about the ABA or other professional regulatory bodies enacting specific AI rules for lawyer conduct. And we're seeing that a little bit in Florida. California is talking about it. But keep in mind that the existing rules, apply to you now and will be used against you if you use these tools improperly. So,
sorry, and I would just note that, that famous case is just the one we know about. There was also a Colorado lawyer just very recently who used it, first lied about using it and blamed like an assistant, and then admitted using it, and he was suspended for like a year. But these are just the ones we've heard about. There's a lot more out there. So these really are the thing that was really dismaying to me is a lot of people, their gut reaction to the Mata v. Avianca case. I was like, oh, well, this is what you get for dabbling in new technology. Like even his lawyers argued that. And I'm like, no. This is not a technology problem. Right. This is what you get when you don't look over your work and you just blindly trust tools. So we're just going to, unfortunately, I think, see more of these come out because they've already happened. Just try not to be the next one.
Well, this is in line with ethics regarding learning technology and even in ethics in marketing with the ABA. Like as a lawyer, whether you've got somebody in-house or you're outsourcing your marketing support to a vendor, you're still responsible for managing the messaging that's out there. Even if you don't know how to use social media, you're not the one posting to it, but they're posting on behalf of your firm. It's still your ethical obligation as the lawyer. We're in law. We're just simply held to a much different, higher standard than most professions are. And as a lawyer, it's at the end of the day, whether you're doing it yourself or not, it's still your ethical responsibility to provide oversight.
And these are not new obligations. These are the same obligations we've always operated under. It's just new technology. That doesn't change it.
Say it again, Stephanie. These are not new obligations. These are just simply new tools. And technology has been with us for a long time. AI has been with us for at least 15 years. This isn't new. Just as a shiny new package.
Right. So unfortunately, situations like we had in the Southern District of New York and Colorado, and there's no question there have been others we haven't heard about, have caused the federal courts to have a reaction, let's say. And so far we're seeing it in the form of judicial standing orders that apply in the federal districts and in the courtrooms of the judges themselves that that propound these standing orders. So a lot of them out there. I think at last count, there's something like 14. The ones that I've noted here are some of the first ones that came out. So the Northern District of Texas was almost, immediately on the heels of Avianca. And then these others where they all take a slightly different approach. But the important things to know are they're generally defining AI very vaguely, broadly, or not at all. So again, it raises those questions to the point Melissa and Stephanie are making. We've been using AI for many years in the context of research in Lexis and Westlaw, a different form of it. Does that mean we can't use that? I mean, it adds questions. How far do you take this, and how, it's hard to enforce. It's really hard to ensure that you're in compliance with it. So does it have a chilling effect? Does it cause lawyers to say, to shy away from tools that could otherwise, benefit their clients and benefit the resolution of a case in the federal court? Some of these standing orders are requiring mandatory certifications or disclosures about not only what you used, but whether you used at all. We've never had that in a federal court before with respect to the use of technology. I mean, this notion that it's such a concern that we have to sign an affidavit or a certification is something that's very new and serious. And then, of course, it's following this trend. So you're starting to see lawyers that are asking questions about use of AI in interrogatories, asking questions about it in terms of the types of questions that we've had in e-discovery for a long time when there's the use of TAR or CAL, those types of questions about like, what was your methodology and how did you come up with this data set or this production set? So it's going to be it'll be interesting to see what standards evolve regarding this in terms of the acceptability of these types of prompts and outputs. So, but the takeaway is, because there's such inconsistency, is to always check your local rules and also the standing order of the judge that you're before. And that goes in state court as well. But in federal court, there's been this more prolific push.
Did we lose Joy?
Yeah, we'll go ahead and move on. So let's go. We've got a couple more slides to talk about in this section. So let's talk a little bit about the White House executive order. Stephanie, do you want to jump in on that first? And I'll be happy to add anything.
Sure. I mean, it was the first. We've been talking. Let's back up for a second and talk about the regulation of AI. I mean, it's been proposed for a while, again, very quickly after ChatGPT came out, and Joy can jump back in here. But I mean, the talk of regulating AI came first, but then how do we regulate AI? Who regulates AI? Like most things, the EU came before the White House. So regulation is far from set in how we do this. The White House executive order is just the most comprehensive US one we've had more recently. I don't know if Joy, if you want to go back a couple slides.
Apologies about that. I don't know what happened. Here we are talking about technology and I'm having technical difficulties, but, the White House executive order, I think it shows the tension here and just the pure breadth and depth of the different impacts of this technology. I mean, if you look at it, it covers just about everything, or purports to cover just about everything. But so it's important to consult it in terms of different areas of the law, HR, marketing, like we're talking about, labor and employment, all of these things. And, it just gives you a sense of how daunting it's going to be to actually enact legislation in the United States that effectively causes something that can be enforced. It's just hard to understand or even fathom how that's going to happen. So. Okay, and then Stephanie mentioned the EU AI Act. We heard news about that just this past weekend. That on Friday they reached this inflection point, this milestone in terms of getting it passed. It's very close to passage now, but not yet final. And it takes a little bit more, in my view, a little bit more of a sophisticated approach to the regulation of AI. And it's always this balance of wanting to promote and not thwart innovation, but understanding the power of it and wanting to keep that in check. So you can read it yourself or read reports about it. But another a point I want to raise here is enforcement. Again, the difficulty of enforcement, and think back to the GDPR and some of the concerns there with those broad regulations of how is this going to be enforced? Is it going to be enforced evenly and fairly? Those types of questions are, of course, going to be raised with respect to the regulation of artificial intelligence in the European Union. So
yeah, I think it's going to be really interesting in the EU. I mean, if you go back a few months, it started with, Italy just banned ChatGPT at first, and then OpenAI talked to them and they got unbanned. So this is a more comprehensive approach than straight out banning. But, there's been talk before that the EU's proposed act is going to be too restrictive and these companies might just pull out of Europe. And I mean, how does that work? Europe doesn't have generative AI and the US does. Like, it's all very much to be determined and not at all clear. And I mean, there are certain questions about, can these tools ever be compliant with certain aspects of the GDPR?
Right. Exactly. I want to move on, but I know we skipped the slide about California. The point to be made there is that in California and other states, they're grappling with these issues too on a statewide basis, not only in the courts, but with respect to what state agencies should be doing to provide some of these safeguards, the types of due diligence and analysis that states should be undertaking as well. So just keep that in mind. There's all these different levels of regulation that you have to think about and check with on a regular basis. And we're going to also give you some ideas on resources in order to keep current with this. So with that, I will pass it on.
Okay. So before we get into the next section about copyright, let me go ahead. For those of you in New York, your New York code for this program is MR33221-121223. One more time, M as in Mary, R as in Robert, 33221-121223. And we'll give that again towards the end of the program. Okay, so let's talk about ownership and copyright and who really owns the content you create from an LLM. All right, so the first question we want to answer is, can AI claim ownership over the content it creates? According to Thaler versus Hirschfield, the U.S. Patent and Trademark Office and the U.S. District Court for the Eastern District of Virginia determined that as a machine, AI does not qualify as an inventor because the Patent Act defines an inventor as a natural person, right? So that's number one, it has to be a natural person. According to U.S. copyright law, it considers a work to be a joint work if it is made by two or more authors intending to mix their contributions into a single product, just like Joy and I did with a podcast interview we did a couple of weeks ago, and Stephanie has also done with me several months ago. But we're natural humans, obviously, but AI systems are not generally recognized as authors for that reason, and therefore cannot claim any right to work created by an AI system. AI tools cannot claim copyright ownership because it needs to be a human creator who's producing the actual content. Okay, now, can you claim ownership? Can a human claim ownership? Well, that kind of depends. So the first thing to know about this is LLMs are using databases of pre-existing human-generated content that by its nature is already copyrighted. So you can't double dip and claim copyright on content that's already been created that you're using just to repurpose and create something new. A human who significantly contributes to or edits content generated by an LLM might be able to claim copyright on their portion only, but again, that's kind of a tricky, blurred line there. And then as far as intellectual property, generative AI raises substantial intellectual property issues. One example that we have here is that the winner of the 2023 Sony World Photography Award had to forfeit the prize after it was discovered that generative AI had actually been used to create the winning piece of artwork. So like we have graphic designers over at RPC. They create everything originally. So there's a lot of people I know that are using, I think it's Dolly and other programs to create beautiful artwork and beautiful graphics. And that's fine. I mean, if you're going to use these systems to create work, you have to make the decision, is copyright important to you? Is intellectual property important to you? And according to some of these regulations and guidelines and laws that are coming down the pipeline, how does that impact your use of these LLMs? And then we all were very aware of the Hollywood strike, the Writers Guild strike, and they finally, after several months, finally came to terms. And the big ticket item there was LLMs or AI being used to write movie scripts and, things like that to entertain us. And so the Writers Guild of America did finally establish guidelines for the use of AI in film and television production. Either one of you want to jump in on that before I move to the next slide?
I mean, it's a lot of this is open questions with any of the litigation we're going to talk about, again, because these technologies are so new. The legal challenges are new. The copyright or the IP area is one of the first that saw a lot of litigation, and there's more and more suits being filed by authors every day. Mm-hmm. How it's ultimately all going to shake out, we're not sure. It's an interesting space to watch, but I would say currently, don't expect that it's going to come out in the way of you have the copyright for it or anything like that. It might, but tread lightly. And like you said, decide if copyright is important to you.
Mm-hmm. And it really depends on how you're using it and why.
Yeah.
So that kind of gets into this slide that kind of ties it up. So as I was doing the research for this article, I did do a poll on LinkedIn, and it's hyperlinked here. So if anybody wants to go take a look at it, you're welcome to. But I did ask the question if people felt that a human can claim copyright over AI generated content. And 53% of the respondents of the poll believe that humans cannot claim copyright over AI generated content. So original works of authorship by a natural human are eligible for copyright protection. So you have to create it. It has to be a natural human. You have to create it natively. It has to be original. It can't be copied from existing databases, which is what AI is using. It's using content that already lives and breathes and exists out there by nature, already has copyrights. You can't double dip. And you have to contribute significantly to it. So again, this is, as I was saying in the earlier part of my presentation, I never, ever, ever take it at face value. And often when I am using it, I'm using it to summarize something or come up with a couple of catchy titles for an interview or a blog article. I'm not using it to create brand new content, and I'm definitely not ever using it at 100% face value. So human authors hold copyright. The copyright owner of AI generated content is typically the human who created the AI system or the human who significantly contributed to or edited the content generated by the system. It has to be a natural human. It has to be original content. You can't double dip in the databases that these LLMs are already pulling from.
And I mean, there's a broader theoretical debate underlying all these cases of I don't know where you fall on whether or not you think it should be copyrightable. But if you think of all these authors that are suing OpenAI and whatever, and it's just well, I could go out there and read 5 books by an author and write a bunch of fan fiction, and that's allowed. So why is this not? And a lot of it comes down to the speed and scale and the potential copyright infringement, but it's far from a clear issue.
Right.
Yeah.
Joy, did you have anything you wanted to add before we move on?
Yeah, just echoing what Stephanie said is watch for some of the inconsistencies with respect to policy and opinion on this because a machine is involved, because a lot of these issues and problems can come up and have come up in the traditional common law without the aid of machines.
And remember, we teased it, Stephanie and I both teased it earlier. Be wary of how Google responds to AI generated content. It's not doing you any favors. And with that, let's move into the final section with Stephanie. And Stephanie, when you're done, I'll jump in and tie it up.
Great. Okay. AI in the news. I would at least from legal tech world, AI hasn't just been in the news; it has been the news for the last year. There's rarely a day we don't write about it, and even if we're writing stories not about it, it somehow finds its way in because it really is touching every aspect of not just legal, but every industry out there. You can see that from the extent to which like every big tech company came out addressing it. Now we have all these international regulations. Like it is the story of 2023. I feel like, at least in the technology space. And I mean, it's really notable that you're seeing major institutions commenting on it too. You know, Harvard Law has a whole initiative on AI in the law. More and more law schools are starting to address it in their educational programs, which is amazing because when I went to law school, I don't even think we talked about technology at all, other than learning how to like search for a case on Lexis, you know. So the fact that it's being addressed, and I think it's raising a broader awareness of technology in general that has been long overdue. There's a task force out of law.mit.edu that this is very much ties into what we've been talking about. They've gotten together and with a lot of feedback, and they're still taking community feedback to come up with 7 principles for the responsible use of AI in law. And a lot of it is what we've talked about. They were saying the one that they found the most debate over on actually was the consent one. Like, do you need to get consent from your clients to use AI? And because you can see both sides of that, right? You can say, yes, they should. But in the past, we never got client consent to use technology before. Why is this different? So people are really, really putting together a lot of concerted effort to try to use this responsibly. Because the takeaway is this is not going away. This is not a fad. This is just going to get stronger and stronger, and we're going to keep going forward. So how do we use it correctly? Between the news and between these companies doing it and in the courts, a lot of these cases end up touching on that as well, the correct usage of it, whether it's ethical, whether it's professional duties. Well, Joy mentioned Mata v. Avianca Airlines. Some people feel bad for the lawyer. Some people don't really feel so bad for a lawyer because honestly, if you look at the facts of that case, he didn't only just use ChatGPT, he tripled down on it. He used it, got questioned, used it again, went back and used it again to generate the actual decisions of cases, like tripled down on this. At no point along the way that anyone stopped to think, oh, maybe this isn't right. Maybe I should actually look at this. There's a lot of common sense that seems to be lacking. And I think that goes with the whole buzz factor. People feel like it's magic. People want it to be magic. But as we said, these are duties you've had all along. This was not a tech problem. No lawyer would take a brief. No marketer would take, a email, a piece, a blog that a junior assistant had written and just not look it over and put it out into the world. That doesn't change because technology did it. So that was an infamous use of it in the courts itself. It has raised some defamation claims, which again, as with all of these litigations, everything is new. Nothing's been fully decided yet. But, this Walters case was like a radio host, and they claimed that he was involved in embezzlement. There was a mayor in Australia where ChatGPT hallucinated that he had been in prison for bribery when really he had initiated the investigation into a bribery thing. When you can imagine, as a politician, that's a really bad thing to have out there by you. There was a law school professor who made up allegations of like sexual misconduct. So it really is. I mean, the potential is there because these things do hallucinate. But again, like in the copyright space, if you bring a defamation claim, who defamed you? The computer, the machine? It's not a human. Who can you really hold responsible? And OpenAI they've been very clear with the fact that these things hallucinate. So the question will be where do you find liability in those cases? Data privacy is a huge concern. We were saying don't put proprietary things in ChatGPT. Samsung is a really famous incident where a coder at Samsung put a line of proprietary code into ChatGPT because it's apparently very good at coding, but it gave their Samsung's proprietary code to the world. That's how easily these things can go out there if you use, and then we're talking about tools like ChatGPT that are public tools. if you're working with vendors who have very specific tools for your industry, your particular business, they should be able to explain where your data goes and where it does not go, more importantly. And you can proceed with those more, but be very, very careful here. And we just talked about the copyright infringement a lot. A lot of these authors are now suing, and it seems almost like once a week there's one, and all of the cases seem very, very similar. And I would not be surprised if they are consolidated at some point. I don't know how they're going to come out, but it really is the IP is the most ripe area, I think, for litigation right now. I would note that, interestingly, on the flip side in the courts, they're not in the US, but there was in Colombia several months ago, a judge used ChatGPT to write a ruling. So judges are playing around with it too. I don't know how that's going to work out, but everyone is trying to figure out how to use it. I mean, I've talked to a lot of judges and they're like, we are so understaffed. If this could help us legitimately ease the load and get to more cases or prioritize the cases we should be hearing, that could be great. But it's all still a question of how and the proper balance and interests of justice. We talked about the standing orders. Again, what does it mean? Certify that, did you use AI in your case? I'm like, well, we've been using AI for years. Do you mean generative AI? What do you mean by generative AI? Do you even know? So half the things we all use in our day-to-day lives incorporate AI, and we might not even know it. So there's been a lot of pushback actually from the legal community against these standing orders, because anything you file with a court, you have to certify for Rule 11 sanctions. You have to certify that it's accurate, that you did your job. I'm very paraphrasing the Rule 11 requirements here, but those requirements that already exist should cover all of this. You shouldn't, in theory, need this extra certification because you're already certifying everything you give to the court. So some see this definitely as either redundant or very much overkill. And it'll be interesting to see how it plays out, because it also just assumes that the lawyers know they're using it. The judges understand what's being disclosed. Again, did you use Grammarly? What does it mean to use it in preparing a brief? All aspects of it? Do you mean research? It's all very, very unclear right now. Which is going to fall, on law firms. Actually, I mean, honestly, like you said, you have to know the local rules where you are, especially if you're in litigation. But regardless of whether it's a judge asking you to certify it, you need to know how AI is being used in your firm. We're past the point where you can ban it. A lot of companies initially were like, we're banning ChatGPT. And I was like, well, that's great. Employees can go home and use it on their phone or on their home computer, or you can't stop them. Shadow IT has been a problem forever in legal. Like, if your organization is not tech forward, your employees are just going to find their own tools to use and do stuff, and you have far less control that way. And it's way more of a problem with generative AI because everyone wants to use it, and these things like ChatGPT are so easy to use that it's going to be a massive shadow IT problem. So you should get in front of it and figure out how you want to use it. Everyone is now having usage policies for ChatGPT, which is important. They cover things like don't put your proprietary code in ChatGPT. And also just like the experimentation, we were saying it's good to play around with these. A lot of firms are starting to use sort of like a sandbox approach, or some tools are out there that allow users to safely experiment in controlled environments where things aren't going out there into the world that you don't want out there. So your employees know how to use these tools and can use them actually to not put your clients at risk, but help you better serve your clients. Mm-hmm. And part of that also is in vetting the technology providers that you are using. So many tech providers now are saying, we have generative AI. And yeah, they probably do. But everyone eventually will. You should ask a lot of questions. Ask them what that means. Ask them specifically how it's being used. Like, they should be patient and willing to answer whatever questions you have. If not, move on to another one. That's true of all technology. If your vendors aren't willing to tell you how it works or answer your questions, I just don't. And security is a major one too, because you can do all the things you have to, keep your own house in order, keep your walls up. But every third party risk has always been a thing, right? Every tool you ever used, every vendor you have, any third party provider of anything opens a door for more security risks. So you need to know that they're also keeping their walls closed. What are they doing to keep your data safe and secure. And again, they should have a very good answer for that. If they don't, move on. And another, finally, training. Technology training has always been a thing, probably not done often enough, but employees should be trained in how to use these tools. We've used the word prompt engineering, the term prompt engineering, as we've gone through this. And I think if you're not really familiar with that is, it's just the art, some call it an art, some call it a science of you put in instructions to these tools for it to generate content to you. And the more you tweak those, you give it more details, give it more instructions, the better you prompt it to get what you want out of it, the better the result will be. And so people are getting training. Like there's like Oric, the law firm Oric trained its summer associates in prompt engineering this summer, and now they're rolling it out across the firm. There's an international consortium of law firms that are now rolling out the same training. There are a lot of, there's a collective of other large law firms that are talking to each other to try to figure out how to do this. You're seeing a lot of collaboration amongst people that have often been competitors to try to get this all right, because everyone is realizing the huge importance of getting it right. And whether it's, you might be a different training for your partners than for your paralegals and then your IT staff. But again, it all comes down to accepting that this is here to stay. It's not going away, and getting your arms around doing it correctly, which goes to, if it's not going away. We started with this fear of, AI replacing humans. That's always been, since Terminator days, like Skynet's going to come, our robot overlords are going to take over. In reality, we are very far from that even being possible, but AI might replace certain tasks. It's not going to replace your whole job, but if you refuse to innovate, your clients are going to go elsewhere. Law firms have long been considered dinosaurs in the innovation realm, whether or not that's earned. Some are more advanced than others. They're going to start. I was at a conference last week where someone on stage literally said, stop paying law firms that refuse to innovate. So it's here. You have to accept it. AI might not take your job, but a lawyer who knows how to use AI will take your job if you don't learn how to use it.
Yeah, and I want to jump in as we tie this up. And first of all, if the audience has any questions, please feel free to use the chat, and we'll take some questions. I'll give you the New York code again here in just a second. But when we started this, I told you a story of how we lost a client to AI and how that inspired the research and the article, and now this ethics CLE as a result. And what we really want to emphasize to you is that this is a tool. It is an assistant tool. It is not a natural human like you are. It is still your ethical responsibility to learn how to use it. It's here to stay. You have to learn this. But I also want to encourage you, wrap yourself around this and dive in and get training for your staff or your employees and learn how to use it. 6 months since this has happened to me, my job is marketing. Whatever your role as a legal practitioner is, that's what your job is, your practice area. But my job is marketing. My job is creating content. So I am using it to help summarize content. I don't use it to create native content, but I have also been writing about it now that I'm comfortable with it. I have been interviewing people. I have been doing podcasts. I have been putting all of my writings and interviews and videos and podcasts out on social to promote my knowledge as a thought leader on this. As a result of that, through social and the email campaigns I sent out with these interviews, I am now not only filling up my pipeline, I am filling up my pipeline with bigger, better, stronger clients than I had before. So I encourage you to wrap yourself around this, really learn it. Don't be afraid of it. It won't replace you unless you just refuse to use it and ignore it.
And I would add to that, not end on a gloom and doom note. Yes, some people feel like, okay, I have to learn this. But once you get into it, it has a huge potential to make you even better at your job, free you up to do the parts of your job you actually want to do, and get rid of, everyone has the little garbagey rote parts of their job they don't like to do. Let it do that stuff. Let it help you get more time, let you be more creative and strategic, and do the things you studied for your profession to do in the first place.
Joy?
Yeah, just in closing, and I feel like it's my responsibility as an AI enthusiast to say, we're obviously focused a lot here on the risk. I mean, that's what we do as legal professionals, is focus on, what's the worst case scenario, but also keep in mind that where there's great risk, there's great opportunity. So like Stephanie and Melissa are saying, not only for our businesses, which of course, is a primary issue, but just to address, there are a lot of issues out there in the world and society that if this is pointed the right way, and if we continue to collaborate and talk to each other, we can actually do some good. So I encourage you to be optimistic about this and embrace it, because as we said, it's here already.
Please connect with us. You can scan the QR code and connect with all of us on LinkedIn. We would love to continue the conversation with you after this program. And again, one more time, for those of you in New York, the code assigned to your program is M as in Mary, R as in Robert, 33221-121223. M as in Mary, R as in Robert, 33221-121223. Please connect with Joy and Stephanie and me on LinkedIn, scanning the QR code, and we look forward to seeing you soon. Thanks for being with us today.